Hey, welcome to Prof. Dan YouTube video. Is this your first time? Or perhaps you've been watching a lot of these videos and you still haven't subscribed? Please, I'm begging, please kindly do so. Subscribe, like, and share. All right. If you have been following immigration medical exams, you know that the rules around Form I693 have been changing like crazy. So in today's video, I'm breaking down the latest policy change that just happened in June 2025. And trust me, this is really huge for anyone filing the Form I-485 applications. So, what is Form I-693? This form is the report of immigration medical examination and vaccination record. And the form is required when you are adjusting your status to become a permanent resident through Form I-485. And this form proves you are not inadmissible to the US on health-related grounds. And this is important to note that as of December 2024, you as the petitioner must submit this form with your I-485 application. There is no exemptions. Let's take a look at a timeline breakdown, the history, what has changed, and what it is at the moment. Now, before November 1st, 2023, your Form I693 was valid for 2 years from civil surgeon's signature. It had to be signed within 60 days of filing. Until that rule was permanently removed in March 2023. Now that takes us to the next timeline, which is April 4, 2024. This is where I think things got interesting. USCIS said Forms I693 signed on or after November 1st, 2023 were valid indefinitely, and that means you could use the same medical exam for multiple future applications, perhaps. And that seems like a huge win for many applicants. That was that. Now, fast forward to June 11th, 2025. This is where I think the plot twists that just really happened. So let's see what changed. USCIS announced that a Form I693 signed by a civil surgeon on or after November 1st, 2023 is only valid while the application the Form I693 was submitted with is pending. This is what it means. If your I-485, for instance, gets denied, that means your I-693 becomes invalid. If you, the petitioner, withdraw your Form I-485, it also means your I-693 form becomes invalid. If you, the petitioner, perhaps want to file a new Form I-485, you definitely need a brand new Form I-693. And these are my own educational, explanation. USCIS has determined that the April 4, 2024 policy, I would say, perhaps is overly broad and could maybe potentially threaten the public health in the US. And essentially, I would say in my line of thought that USCIS has realized that letting people, petitioners, use the same medical exam indefinitely perhaps wasn't the best idea for public health monitoring. Okay, and here are my key takeaways. If you filed your Form I-485 and it's still pending, you're fine, you're okay. This change doesn't affect you. This is where it probably gets expensive though. Let's say you filed your Form I-485 in 2024 with a fresh I693, but USCIS denied your case. Under the old April 2024 policy, you could still reuse that I693, but now you can't anymore. You have to start that medical examination I693 from scratch again. For those of you planning to file soon, you have to factor in now that your I693 is now tied to that specific application only. We've had cases of petitioners who, even while they are starting the very first time filing Form I-140, maybe through the EB200W or the EB1A, they also file concurrently, including their Form I-485 and their medicals. So you have to put all that to consideration. If eventually you are not approved, that Form I693 is also invalid. If you want to file again, you have to use another one. Make sure. There have also been questions about COVID-19 vaccination updates. Please also do note that on January 22, 2025, USCIS announced that as of January 20, 2025, officers would no longer issue any request for evidence or notices of intent to deny related to COVID-19 vaccinations. So it simply means that COVID-19 vaccination is no longer required in your Form I693 for adjustment applications, pending on or after January 20, 2025. I think civil surgeons can now cross out that section or probably write not applicable in the Form I693. For viewers, for petitioners who are waiting for their priority date to be current, I'm talking to those who already have an approved I-140, and you are now probably considering, what about if you go do your medicals, your Form I693, and clear that out of the way so that when your date becomes current, that is no longer a delay, right? Just ensure you time it carefully. You probably know where the date is now. You probably have a few short guess of when your date will become current. Apparently, if it's still going to be less than 2 years, then no worries. You can still, try to get that out of the way rather than waiting for your date to be current and now, at that moment, now proceeding to do your Form I693 medical surgeon. Again, it's your choice. I'm just giving out my own educating, guess. In my view, I expect we will probably see more refinements to these rules and policy. I think the pendulum swung too far towards indefinite validity of the Form I693, and now it's swung back. So we might probably see a middle ground eventually in the future. Please note, immigration policies change fast. Make sure you are subscribed for updates, right? Make sure you subscribe for updates and always verify current rules before making decisions. Verify from the official sources, okay? Always remember, I'm only providing educational information based on the current USCIS policies. Ensure you consult immigration law. I wish you all the best and see you in another video. Peace.